And then the last story we want to talk about today is one we covered. I think this might be one of the first of the kind rulings since the Supreme Court handed down their Bruin decision, but it's dealing specifically with gun purchase waiting periods. This one deals with Colorado's 3-day waiting period, where a judge actually just denied a preliminary injunction. So he upheld that waiting period and did so under kind of an interesting reading of how that implicates the Second Amendment, or how it doesn't actually implicate the Second Amendment. And then you wrote an interesting analysis piece where you characterize it, I think, appropriately.
Yeah, this is what I call the one weird trick approach to Bruin. I think I called it in the piece the one weird trick theory of Bruin. The one weird trick that plaintiffs hate, which is essentially because we actually saw this once before. The logic, it's a different case. The other case was about the California's ban on possessing homemade firearms that are unserialized. But the logic in both cases is exactly the same, which is the Second Amendment guarantees a right to keep and bear arms, but it doesn't say anything about buying, making, or selling them, acquiring them. So there's no protection offered to that activity at all by the Second Amendment. That's essentially what both of the judges in the cases that I'm talking about here ruled, including this Carter appointee, which, I mean, by the way, like, impressive that he's still on the bench, being a Jimmy Carter appointee. Right. He's got to be in his 80s, I think. But I guess that's the trend our politics have seen lately, is that nobody ever retires here. They will keep being president or running for president or staying on the bench or staying senator until they literally die in that position. It seems like that's where our politicians are at now, and our judicial figures. But regardless, he ruled that the 3-day waiting period for gun purchases is okay because the plain text of the Second Amendment does not cover gun sales or gun purchases, or and presumably this would also extend to shooting. Doesn't actually, it only covers the literal keeping and bearing of them. So holding ones you somehow already have, or carrying them around on you, but not, I guess, also not shooting them in any way for any reason, and not acquiring. I mean, that's why it's kind of a joke. Our tagline here is sober and serious, and I tried my best to take a fair look at, especially in court cases, at the reasoning that's being used. And there's a lot of disagreement about how to apply Bruin to different questions. And you have a lot of judges who of good faith who come down on different sides of the same policy as to whether or not it's constitutional. But sometimes you get stuff like this, which is just kind of, I mean, it's not a serious attempt to grapple with the constitutionality of this law. There are interesting questions around, like, what are the limits of regulation on commercial sale of guns, right? There's probably a lot that you could do to look at do an actual Bruin analysis of that and see, how have we regulated commercial sales of firearms in the past? And, like, how does this work? And is there some difference today that, the mass production of guns is different than what existed at the founding? Should that factor into a Bruin analysis? There's a lot you can go into and have a serious discussion or serious attempt at making that case. But this just isn't that. This is like, oh,
right.
Here's the one weird trick. Just ignore the second, just say it doesn't apply to anything. Government could ban guns tomorrow if it wanted to, I guess. You can't shoot them, you can't buy them, you can't make them. All you can do is keep and carry the ones you have. You can't, but even if you're carrying them around, you're bearing them, you can't shoot them. It doesn't say the right to shoot arms. It's just kind of an unserious thing. Yeah.
And another thing the judge did is something we've seen in other cases too, is something I call like that, the heads I win, tails you lose sort of side of the argument, where they say, this doesn't implicate the plain text because the plain text doesn't say anything about buying guns. But if it did implicate the plain text, here's the history that I say would support waiting periods. And in this case, the judge says historical colonial era laws prohibiting intoxicated people from bearing arms covers waiting periods because, well, those laws were aimed at preventing impulsive acts with firearms by drunk people. So therefore, a 3-day waiting period, which lawmakers say is about impulsive acts, therefore, those are the same, and that would be a valid historical analog.
Yeah, so that was another thing too. Like, he obviously wasn't very committed to this idea that the plain text doesn't. I think he understood that that's not going to be enough as the case moves along. That I don't think that even in a more left leaning circuit, that the higher that once it gets to an appellate panel or the full panel, or especially the Supreme Court, that they're not going to be satisfied with that explanation. So he did but honestly, it's a pretty half-hearted attempt to do the Bruin analysis, as you just sort of outlined there. He says there were laws that allowed government officials to disarm somebody who was intoxicated. Usually these were like militia regulations, essentially. Like, if somebody's on duty, they're carrying their firearm and they're drunk, they could be disarmed. And he said that is an analog for a 3-day waiting period to purchase firearms, which is, I think, pretty thin. And interestingly, somewhat ironically, we did have another ruling this week that would more directly implicate those restrictions from the founding era, right? Which was, we had a case out of Pennsylvania, out of the Third Circuit, about a man who he'd been convicted of two different, convicted is maybe there's a little nuance here. He'd been convicted of a DUI in 2005, and he received a sentence enhancement because he had previously been arrested for a DUI in 2001, and he had served like a diversionary program for that first DUI arrest, where it wasn't a conviction, but if he reoffended within a certain time period, which he did, then that would result in a sentence enhancement. And so, even though this technically under Pennsylvania law is not a felony, it's a misdemeanor, it was punishable by up to 5 years in prison. Now, he didn't serve those 5 years. You can sort of see how this stuff gets into the weeds here, but he served like 90 days house arrest because he had a medical condition. But regardless, that qualified him as the same as a felon under federal law for the purposes of lifetime disarmament. And a judge ruled that his disarming him for life was unconstitutional, that the law as applied to him was unconstitutional, and that even though we're talking about a DUI in this situation, now he didn't have a firearm when he was committing a DUI or what have you, and it wasn't a violent offense. He didn't harm anyone else. Obviously, he could have. He was driving drunk, but he didn't. That there still wasn't a close enough analog because, one, it wasn't a lifetime disarmament for people who were disarmed while they were intoxicated at the founding era, and two, it was only when you're actually intoxicated and carrying a gun that those rules applied at the founding. So, on the one hand, you had a judge whose case was, I think most people would say, much closer to the founding era regulations. On the other hand, you had a judge, and he said, no, this isn't a good enough analog for a number of valid reasons, I think. But, and then you had this judge in Colorado say, well, sure, that's close enough. It's sort of related. It's something about impulse. I really don't understand how he's drawing an analog there, but something to do with drunk people are more impulsive, and that makes them dangerous. And people who buy a gun and receive it immediately could act on an impulse, and that's kind of, I guess, what he's trying to do.
Right.
But it's interesting to see the dichotomy there between two different federal judges approaching that issue. And I think it underlines how little effort this federal judge put into upholding that waiting period law. But anyway, I don't know. That's just something that occasionally you come across a reasoning that's just, I don't think is going to go anywhere and isn't really meant to be terribly serious.
Yeah. And then the plaintiffs in this case already said they're going to appeal this to the 10th Circuit. And to your point, I would be surprised if the 10th Circuit echoed this analysis.
Me too.
I'll just leave it at that. But.
Me too. I mean, I wouldn't be surprised if they upheld the law by some other means.
Sure.
Perhaps maybe a bit more serious examination of the law under Bruin. But yeah, I don't think this one's going to be the one that does it. I don't think this is what the court is going to adopt. The Supreme Court is going to adopt as a logical interpretation of the Second Amendment.